Hi there, and welcome to MiWeek. Thanks so much for joining us. I'm Christy McDonald. It has only been a couple of months since Detroit officially emerged from Chapter 9 bankruptcy, and now the judge who presided over the history-making case has hung up his robe. Judge Steven Rhodes has officially retired. It's something he wanted to do 2 years ago, but he put those plans on hold in order to accept the landmark case. Coming up on MiWeek, the judge gives his first interview since the bankruptcy. He talks about the city's decision to file and about his ruling on reducing pensions. Plus, a new report card is giving some low marks to charter school authorizers in Michigan. We will take a look at accountability for school performance. And NBA great Earvin Magic Johnson makes another step toward revitalizing the former state fairgrounds. It is all coming up for you on MiWeek. But we do start with Detroit and Judge Steven Rhodes' first post-bankruptcy interview. The judge has been praised for the way he handled the courtroom in the precedent-setting case. And this week he spoke exclusively with WDET 1019 FM about the city's decision to file for bankruptcy, the importance of the grand bargain, and his controversial ruling concerning public pensions. Here's an excerpt from that WDET interview.
I was actually of the opinion that Detroit should have filed bankruptcy years before it actually did.
How early do you think even?
In 2005 and 2006, the city entered into a disastrous financial transaction to shore up its pension obligations. It's sometimes called the cops and swaps transaction. I felt that all the indicators for bankruptcy were apparent then, and perhaps before then even.
Does bankruptcy court have the ability to really make those big sort of structural changes to the fabric of a community, or is it really just about the balance sheet?
It's really much more about the balance sheet than anything else, and this is especially so. People really need to understand this. This is especially so in a municipal bankruptcy case where the bankruptcy court's jurisdiction is really severely limited to debt adjustment. We do not have the authority to supervise the reorganization of the city's municipal service delivery processes. That's still up to the elected leaders and the democratic process.
Was the grand bargain, which I guess we should restate was an agreement between several parties to come to the table with large sums of money, how integral was this so-called grand bargain to the bankruptcy being wrapped up in sort of a timely and orderly fashion, all things considered?
It was the key to the ultimate prompt resolution of the case for a range of reasons. First, among the city's most strident opponents in the case were the retirees. They had fought eligibility, and that was on appeal to the Sixth Circuit by a direct appeal. Bringing them in and settling with them was essential, crucial to kickstarting the conclusion of the case. Beyond that, because it was the first settlement, it really started the settlement dominoes falling because it provided the city with a very strong settled class of creditors, and the other creditors could see the importance of attempting to settle with the city.
I just wonder if you think that will ever be replicated in another bankruptcy case, or you've had inquiries about that from judges around the country and putting something like that together.
I really feel that Detroit was unique in that regard. In this context, I have to say again that the work that Judge Rosen and his team did on the grand bargain was absolutely miraculous and unprecedented, not only in the history of bankruptcy, but in the history of mediation, as far as I know. They went outside of their roles as mediators to go out and solicit money to solve the city's problem. It will be for other people in time and in history to judge what precedent this case has. Legally speaking, there isn't actually a lot of legal precedent in the case because so many issues were settled. I suppose the one major precedent in the case is that in Michigan, under our Michigan Constitution, pensions can be impaired in a bankruptcy case. In terms of procedural precedent, it really just continues the precedent of other municipal cases that the way to resolve them is not through litigation, it's through mediation and negotiation.
And by the way, Judge Thomas Tucker was just appointed to handle a few remaining issues in the city's bankruptcy case. So let's start there with our MiWeek contributors, Nolan Finley of the Detroit News and Stephen Henderson from the Detroit Free Press. Gentlemen, it's good to see you, and I will apologize up front that I do sound like B. Arthur today because I have a little bit of a cold. So
she had a very successful career.
Yes, she did. She did. So bear with me. I think it's really interesting, and Nolan, let me start with you. Listening to Judge Rhodes, because we never really got an opportunity to hear his voice. And one of the things he talked about in that interview was the fact that no one from the media challenged that First Amendment, that perhaps this would be a defining case he could rule on in having broadcast this case.
Well, I mean, and that is, I think, one of many places in this bankruptcy that we didn't get to see things litigated. He mentioned the grand bargain. He mentioned pensions being one of the places where there was precedent. But you take that to, none of those things went to the Court of Appeals. And so this idea that this case was going to be some sort of guidepost for cases all over the country, I don't think it ever materialized.
So what do they talk about in Law School 101 when they opened up the Detroit bankruptcy case?
Well, I mean, I think they will talk. I think the grand bargain, even though it's not precedent because it's part of a settlement, is a unique feature of this bankruptcy. I don't think anybody has ever seen that happen before, but both in terms of the amount of money that came in from outside the case, from parties who were not part of the federal action, but also the fact that all of that money went to one class of creditors. You had $700 million come into the case that all went to soften the blow to pensioners. The banks, who were taking much bigger haircuts, didn't get any of that money. I still believe that or I should say, I would love to hear Judge Rhodes explain how that's fair or how that comports with bankruptcy law. Obviously, he believed it did, and they settled. But I'm not sure that the books say it should work that way.
And it doesn't matter. I mean, again, you said the key words. They settled, and I think every contentious issue here, every issue,
got settled,
was the result of a settlement. So again, he didn't have to impose anything on any class of creditors.
I would love to hear what his initial impression as a judge was when somebody said to him, "We're going to try to raise all this money to help the pensioners and not the banks." Again, drawing that distinction among creditors is on the books, not the way bankruptcy is supposed to work.
Don't you think
how did he think that was okay?
Don't you think it would have been it's helpful though that Judge Rosen was also on that part of it
no
as
question.
well?
I mean, you had the chief judge of the district court saying this works, and he structured it apparently in a way that Judge Rhodes was okay with. I think if you had banks say, "Hold on a second, I'm not going along with this, and I'm gonna challenge this at the district court level and maybe appeal it," I'm not sure how the Sixth Circuit would have seen that differential treatment of creditors in the same class.
The judge said that the pension question, Nolan, was pretty much cut and dry for him. Are you surprised that was never challenged?
Well, it was a challenge. I mean, but again, they ended up settling it as a result of the grand bargain. I would have been very interested to see how this thing played out if there weren't the grand bargain and that issue were truly tested at the Court of Appeals level, where it was, where it went, but was drawn back because of the settlement. So there's a lot we don't know because Judge Rhodes, Judge Rosen, the mediators were so efficient at settling all of the contentious issues.